Welcome back to the Slingshot. Today's special guest is Brian Callaci, Chief Economist at Open Markets and author of the new book, Chain of Command, The Rise and Cruel Reign of the Franchise Economy, University of Chicago Press, which we will be discussing today. Brian is also visiting assistant adjunct professor at John Jay College, where he teaches industrial organization to master's students in economics. A quick word about Brian's background. Before going to grad school, Brian had stints working at the labor unions Unite Here and Workers United, and served as a staffer at Change to Win, a coalition of labor that gave rise to the Fight for $15 movement. In 2013, Brian left Change to Win to enter the PhD program in economics at the University of Massachusetts Amherst, where he wrote a dissertation on franchising. Joining me today is my partner in crime, Darren Bush. Darren, how's it going?
It's going well, thank you. I'm looking forward to today.
You ever work at a franchise? I don't mean to put you on the spot here. Would you ever flip burgers or anything like that? Or manage one?
No, I worked at a country club as a golf attendant, so I got to see the great side of wealth.
I don't know if that counts though. Darren, I don't know if we're gonna allow him into the franchisee family with that answer. But anyway, in addition to talking about Brian's new book, I wanted to hit on a few labor-related things in the news, just because we have Brian, an eminent, labor economist here, just to let us know what we should think about AI and its impact on the labor market. And I also wanted to talk at the very end, if we have time, about Brian's empirical paper on the impact of no-poach agreements imposed by franchisors on franchisees. Might as well stick with this franchise theme if that's okay. Brian, does that sound like a fair deal?
Yeah, let's see how it goes.
Okay, well, we're just making this shit up. Let's talk about the impact of AI real quick. I was wondering if you were following that debate among economists on the impact of AI adoption on jobs. The New York Times had a cover story last week, Ben Castleman. I don't know if you saw it. I'm just curious, are you in any one of these camps? I think there's a no effect camp. Don't worry about it. No effect yet, but it's coming, and it's already here. Put your head in the bunker. Where are you among those three?
Yeah, so I would really love to get your guys' opinions on this, but I would say that I'm somewhere in the middle, that we're not, it's not time to head to bunkers. I think no, as people that that we, for a living, we do regressions, we should not anthropomorphize them. I think that's a weird thing that people do, that these are intelligent regressions, that then there are people with big financial stakes in trying to sell us on the awesome capabilities of logistic regression models, no matter how many layers of random forests or whatever you put on them. They are just regressions. So yeah, and we should talk about, I think there's a couple ways to think about it. And again, I want to get your takes, but there's labor displacement effects that are potential. This is something that this is economic history. Is we don't have people working on making buggy whips anymore. This is just happens. There is a steady progress of labor displacement. That's fine. There's also this labor discipline effect that we can talk more about. But yeah, I guess one thing I'll just say that I find kind of interesting is the attempts of the people with financial interest in selling this technology to us, in trying to make organizations more dependent on them. So there's one economist who maybe some of you guys know about Peter Dorman. I think he's at Evergreen State. But he wrote this, I thought interesting. I think maybe that was on a Substack, but his piece about how what Doge was really about, these kinds of was creating an anchor customer for these companies that are not that profitable yet, but they need to, you can't just little add-ons with, oh, it helps you write your emails a little faster. But what they really need, if they ever want to really turn a profit with this stuff, they're going to have to restructure businesses to really be dependent on this. And what better way to do that than to get the federal government and big anchor institutions like public universities dependent on this technology. So I see it as, if it happens naturally, we're in for a longer term, slower rollout than what I think some of the more catastrophic scenarios are. That's just me, though.
But Brian, let me tell you the real reason why I wanted to bring up this topic. One of the themes in Ben's New York Times piece was that the attitudes of IO economists have shifted over time. When the initial threat kind of manifested itself, they were quick to poo-poo that threat, and now they're slowly coming over. Are they just tracking kind of popular opinion on this thing, or do you think there might be some more nefarious reason as to why IO economists would be insensitive to the plight of workers given this threat?
Yeah, I think that and first of all, there's an ideological issue of a lot of economists see workers more as inputs to production as, versus human beings. So, not to put too fine a point on it, but I think there's that issue. But I think also, we as economists, we study incentives. That is kind of our bread and butter, and which side of these debates has more financial firepower on their side? It's not the side of the workers. That's just without casting aspersions on anyone's professional judgment or what side they choose to represent. But look, the Senate incentives matter, and those incentives are not on the side of working people when it comes to assessing these impacts.
So I know you're familiar with Braverman's work, Labor and Monopoly Capital, and he argues that the skilling of workers eventually creates a homogeneous, unskilled labor pool. And so, AI fits quite nicely with that theory, I think. But others suggest that, 'twas always the case that labor moves to some other use when technology intervenes and kind of creates new labor. Is there any evidence bearing out which theory is more correct?
Yeah, so I think, like I said earlier, I think we should draw some distinction between the, labor displacement effects of these technologies and the labor discipline side of things. There's, as we have seen over time, and again, I want to de-emphasize how much is new about, the machine learning or AI aspects of this. But there's economists from Frederick Guy, Peter Scott, Lester Thurow, Robert Gordon, of course, Braverman, who are focused on the effects of the surveillance aspects of these technologies. So it's not just displacing workers; it's making, this is Braverman's thesis, is making, the tacit knowledge that workers have on the job more codified, explicit. You train your supervisor to take your job. You train a robot to take your job by having that surveillance technology look at how you go about, how you drive your truck, how you handle packages, whatever it is that you do with your job. I think that's not something to frown at. That's something that gives employers more power. It gives a smaller number of supervisors can now surveil a much wider range of workers. They can use technology to misclassify those workers as independent contractors, using them, surveilling them, controlling them through algorithms rather than directly employing them. There's all kinds of this sort of intersection of legal changes and technological change that I think, yeah, can certainly be a threat to disempower workers and bring that wage down to the bare reservation wage, or even below, of what most workers will be willing to accept.
Yeah. Something that caught my attention in the piece is that Ben interviewed economists as to what they thought the right remedy was, assuming there was, in fact, this effect, it was threatening jobs. And I'll notice just by selection that the people he interviewed were those who had researched on the impact of AI on jobs. Okay. So take that however you want. Their response was mostly retraining programs, right? And I consider this to be a bit milk toast. I feel like telling someone to retrain, learn to code. We've heard this kind of stuff before, the free trade effects. I don't know, where are you on retraining? I think I might know. And if not, and if retraining isn't the right thing, then what is the right thing to deal with this threat?
Yeah, I think economists, we're getting better every year. I swear we're getting better, particularly with the younger people. But allergic to understanding power and how that works in the workplace, and how that works on the job. So having more, retraining. We have plenty of evidence now that did not help, in the concentrated effects of workers that lost their jobs in places like Kannapolis, North Carolina, in some of the auto supply parts regions of the country after NAFTA. Uh, Increasing worker productivity, even if you accept the notion that giving someone a community college certificate or giving them more training will in fact raise their productivity in a way that translates into higher wages, that we just have not seen that actually raises the workers' bargaining power on the job. You need other things for that: higher minimum wages, tight labor markets, collective bargaining power to for workers. Is a wonderful paper by Anna Stansbury and of all people Larry Summers on how workers have lost the ability to demand a share of the for what lack of a better term we economists call rents produced by production markets. Things like workplace fishing. There's been all these kinds of mechanisms that employers have for the last 50 years excluded workers from the whole worker rights infrastructure created by the New Deal, where workers could claim a share of the revenues that they jointly produce, and that they just don't have that ability in the same way they used to. So the fact that if you're just going to give them a community college certificate, retrain for a different job. Claude can already do a better job than I ever could when I first started out, writing code for R. So yeah, it's I just don't find that a plausible. So I don't think any worker in America would of just raise your skills. We need more bargaining power for workers.
No, you mean like thank you for your consolation prize, but no. Um, So let's talk legal profession because I'm a lawyer and so I only worry about myself. And we've seen we've seen massive instances of AI generating false citations. Lawyers getting sanctioned by the court. These AI not summarizing case law properly. And in the other professions, we've also seen similar problems where there was a recent study in terms of therapy that suggests AI violates ethical standards in therapy environments. And in medicine, we've seen a push for AI to complement doctors in diagnoses with companion studies suggesting in most areas a higher degree of accuracy than doctors alone. So how should economists, whose jobs are apparently secure, evaluate the productivity gains and labor market impacts of AI in high-skilled professions when the technology simultaneously increases accuracy in domains like medical diagnosis, yet produces significant error rates in other fields?
Yeah, so that's a big one. So first of all you have your type 1 and your type 2 errors, and we got to be careful about which ones we're more concerned about in a given context. But I think that's just it. I mean, can you hold a algorithm responsible for an ethical decision? And I think we do need, just my opinion as not as an economist, just as a immoral person in the world, whoever makes the decision, you have to be able to hold someone accountable for the outcomes of what they've decided. Economists, we have wonderful tools. We should be called upon by the public, by legislators, by courts to use those tools to help them understand how to quantify risks. We should be in the conversation. But in my opinion, it needs to be democratic publics, more accountable. But you cannot outsource these kinds of what I think are fundamentally moral, ethical judgments to algorithms. And I think that is a fundamental problem with this.
All right, let's switch gears to your book, Chain of Command, which, by the way, just for my readers, the readers out there, I've found it to be so well written. I just got to commend you on the writing style. It was fantastic. I mean, the pages just turned effortlessly. So I commend you for that and bravo. But let's talk about the substance of the book. The book finds the roots of workplace fissuring strategies in law and regulation rather than technology and efficiency. I think this is a thesis, one of the theses of the book. So can you explain to our listeners how the franchise structure of fast food restaurants became an impediment to things like unionization efforts, the ability of workers to raise their wages or to improve their working conditions? I don't think that's going to be obvious, but maybe you can kind of break it down for us.
Yeah, sure. I'll give it a shot. So, I think it's one of those things where Yeah, having yeah, viewpoint diversity in academia can be helpful, because I used to, I was a staffer, working for labor unions, and these kinds of business structures, what David Weil at Harvard calls the fissured workplace. It just it's kind of obvious, if you're a worker, or if you work in these industries, that a part of the motivation for using these kinds of business structures, where you have large corporations that are able to outsource their employment responsibilities to independent entities, or even to just classify all their workers as independent contractors. A big benefit for that is you get control over your corporation, but guess what? You don't have to be liable. You can shift all that risk, all that liability onto a third party that, by the way, is often judgment proof. If you're working for a small business franchisee, and you try to sue that franchisee for wage theft, they may a very convenient way of dealing with that problem for the big corporation is you can just terminate the contract and not deal with the franchisee at all. So yeah, there's, and I think that one of the things that the book, I hope, contributes is that this oftentimes this is told in terms of technology and efficiency increases that have, with the declining transactions costs of the 1970s and 80s. And that I wouldn't say that that's not any part of the story, but the timing doesn't work out, because a lot of this stuff happened in terms of the stuff I talk about in the book well before that. I'm talking about the 1960s, 1970s. These are companies that are engaging. The Chicago Revolution is often told as just a sort of intellectual story of these smart guys at Chicago, and they were able to convince jurists of their superior ideas. But the actual cases that were filed, the litigation strategies, was just by these guys like the founders of McDonald's and Dunkin' Donuts, who decided, you know what, we really would like to be able to have national and international networks of businesses, and we don't want any liability for that. I can, talk in more detail about how some of that looked, but this was a decision they talked about this openly. This was not a secret. They published all of their strategies for doing this, and that was the goal. Is we want to have control over these transnational or organizational networks, and we don't want our employees to be able to have unions. We don't want to be liable for vicarious liability, or for whatever it is. That was sort of the goal.
I I love this line from the preface. You say, quote, when industrial organization economists looked at franchising, they didn't see the union avoidance or legal arbitrage strategies that I thought were core to the business model. Rather, they saw efficiency. So you might be detecting a theme here, but what is wrong with mainstream IO economists? How did they miss this? And is it possible that their anti-worker attitudes are shaped by corporate funding sources?
Yeah, and I can't speak to that because I don't know exactly what their funding sources are. I just know the literature, so it's just a yeah. But I've been very puzzled to see how yeah how this whole structure was able to be created. I'll say that there was this wasn't always considered part of mainstream antitrust jurisprudence. One of the examples there's several, but one of the ones I use for my book is there's this I think this wonderful moment there's a Senate anti-monopoly subcommittee hearing in 1965 with Jerry S. Cohen, who is he's the chief counsel for the subcommittee. And his boss is Philip Hart, who's one of, an important anti-monopoly U.S. senator. And there's the president of the International Franchise Association who's testifying to the subcommittee, and this guy is trying to argue that franchisors, McDonald's, Dunkin' Donuts should have the same, and I mean the same, ability to command and control their organizations through, what we call in antitrust parlance vertical restraints, but what we mean is those, incredibly restrictive contracts by which, every McDonald's in the whole world looks and feels identically to every other one. We should have the same right to order around the employees of those McDonald's that we do our own corporate headquarters staff. And Jerry Cohen, the chief counsel of the subcommittee, just can't believe his ears, and he responds, I'm just going to quote, then what will be the difference between a franchise operation and an integrated corporation? That the argument we get here for franchising is that it allows an independent businessman to be independent, but if he is told what product he has to buy, what prices he has to charge, what operation he has to operate in, then he is no longer independent, is he? He is part of an integrated franchises operation. And I think that's sort of this legal fiction that they've been able to create that I think that antitrust economists, IO economists have not quite grappled with, where we have this whole body of law that protects workers. So we have the National Labor Relations Act that guarantees your right to a union. We have the Fair Labor Standards Act, which guarantees your right to minimum wage, overtime, and other workplace protections. We have OSHA. We have all of these laws that are designed to protect your status as a worker. And then we just create this loophole through antitrust where, you know what, if you don't use a formal employment contract, if you just use vertical restraints, if you just use these other tools that have since become legal loopholes, that's okay. That I think that when we see people like the great jurist Frank Easterbrook talking about how price fixing doesn't mean anything, in terms of economic, whether it's between firms or inside of a vertically integrated corporation, that means something to the independent contractor, the Uber driver, who has to charge the price for that ride and accept the price that Uber dictates to them, rather than being as a truly independent entrepreneur being able to set their own price. So I think that's an important distinction.
Well, let's talk profits, and I'm going to try my acting chops since my job's on the line with AI, and I hear acting is just going to be fine. You in the movie The Founder, there's a famous quote: "You don't seem to realize what business you're in. You're not in the burger business. You're in the real estate business. You don't build an empire off a 1.4% cut of a 15% hamburger. You build it by owning the land upon which that burger is cooked. What you ought to be doing is buying plots of land and then turning around and leasing said plots to franchisees who, as a condition of the deal, should be permitted to lease from you and you alone." So that makes it sound like the profitability of the franchisor is based entirely upon land deals, but you paint a more sophisticated story of how profits are gleaned from more than the burger, and perhaps more than the land, right?
Yeah, so that is not, and by the way, it's a wonderful film. Everyone should see it. Michael Keaton is amazing as Ray Kroc. Yeah, anyway, I'm not going to try to fanboy off too much about that. But I no, but I think there's an important element here that we need to acknowledge about why McDonald's owns the land. And they borrowed this strategy from petroleum companies in the 1920s and 1930s, who would again, this all depends on what the law is at the time. They at first, Sunoco and all, the Standard Oil, all of the, Shell, all these big companies would, it had networks of petroleum stations throughout the country, and they would employ dealers to, operate those stations and pump your gas. And then it came to be that there were laws against chain stores, so they weren't able to operate that model in the same way. But the key thing is what the dealers came up with was a way to gain control over those gas stations without actually employing the dealers. Was, you know what? It's your gas station. You're going to sell it to me. I'm going to lease it back to you, and it's going to be a 1-year lease. And guess what? If you don't obey my commands on what price you're going to charge, of what tires you're going to be able to sell, over what else is going to be the inventory of your store, I'm going to evict you from it's your business under all the laws. It's an independent business, but I have the power to evict you from that establishment. And we've talked about this antitrust concept of vertical restraints, but you don't even need to have a contractual rule if you can just evict a supposedly independent business owner from their entire business. And that is what Ray Kroc sort of discovered by being able to own all of those stores. Actually, you know what? I actually do have a quote here. Here's what Ray Kroc says. This is his own autobiography. Quote, I have finally found the way we will put every single McDonald's we open under our complete control. Dot, dot, dot. Now we will have a club over them, and by God, there will be no more pampering or fiddling with them. We will do the ordering instead of going around and begging them to cooperate. End quote. That is the point of owning the land. I'm sure, look, there's all kinds of revenue, and Ray Kroc was in fact a real estate genius. I'm not going to deny any of that. But really what this was all about for him was being able to control these independent franchisees. And yeah, what's a better source of control than, you know what? I can evict you.
Yeah. The International Franchise Association, or IFA, is, I would say, the main character in the book, or maybe I should say the main villain in the book. They seem to be getting in the way of legislation that would have helped out some of these franchisee owners. And you write, quote, the IFA's singular objective, sustained over more than 6 decades, has been to give large corporations the power to dominate and control small businesses and workers, while also deflecting legal and economic risks and costs onto these same less powerful actors, end quote. Now, I was wondering if you could just tell our listeners a few things about the IFA, aside from what I thought was kind of funny, that it was started by the founder of Dunkin' Donuts.
Yeah, well, yeah, a real business visionary, as these people were. Yeah, but this was a sustained effort. I think it's important to recognize, that this whole business model was not really legal in 1960 when these companies were just getting started. Amazon, with their outsourced delivery program, Uber, Lyft, DoorDash, these business models were not really legal, and so you have these, they're not just business entrepreneurs, they're also legal entrepreneurs trying to figure out how can we establish this business model. We don't want to obey the laws. So we need to find a way. This is an early version of move fast and break things. We don't think these laws should really apply to us. We think that we are innovating a new kind of business model that does not require us to obey the laws that have protected workers and people, vicarious liability, all kinds of branches of law. They thought that should not apply to them. So that's what they decided to do, and they spent several years, several decades, crafting a sustained lobbying and litigation strategy to do that. And they were largely successful. And it's been sort of an unsung, I think, part of our sort of our legal and business history, is that they won this battle, and now we have all of these other business models that have been able to sort of follow in their footsteps. Yeah, and yeah, it was a concerted effort.
Okay, so let's talk about the role of the immigrant population, and you mentioned in chapter 4 Larry Fasciano, who worked in his family's New York shoe store for 20 years, and then wanted to close the family shop and open a Dunkin' Donuts restaurant. We were being eaten up by the change, he explained to a journalist, so he joined up with one, abandoning his family's independent business to buy a franchise, close quote, close quote. So it's interesting, the makeup of the franchisees related to the immigrant population in your book, with 60% of the Dunkin' stores being owned by descendants of immigrants. But you also point out that success was not felt by Black franchisees. Why not?
Yeah, so I think the classic work there is only a few years ago, Marcia Chatelain's book franchise, The Golden Arches in Black America. But there's a few things going on. I think one thing is that you have franchisees who, if you were trying to open a coffee shop or a hamburger stand or any of these kinds of businesses, in let's say 1950, you might have access to, productive assets. You might be able to get out, a small loan to, you can buy a stove. You can buy the equipment, physical capital you need to start a business. But most of these businesses are sort of run by, what Herbert Simon would call satisficers, people who are just trying to make an income. And what changes with the arrival of franchising is that these businesses become sort of brought into they are not allowed. You're not just allowed to make this is a constant refrain of franchisors of, what if my franchisee who operates the McDonald's gets too comfortable and just wants to make, 100,000 a year so they can have a nest egg for their family. So there's this really intense effort by franchisors. They're always obsessing over this to get how do I get them to keep working at maximum? How do I get them to keep having their kids work in the shop? How do I get them to keep, working as hard as possible? But a lot of this initial growth happens in a time when Black Americans are excluded from these kinds of business opportunities. That's sort of the Chatelaine tells. This was Richard Nixon's whole strategy for what he called black capitalism, which would be, we'll give the way that we'll sort of deal with urban rebellions of the 1960s and economic inequalities, rather than really address those inequalities at the roots. We already have Ray Kroc, we already have William Rosenberg of Dunkin' Donuts. They're going to be the billionaires, the millionaires. Let's give Black Americans sort of a junior partner role, within that system, but not at the top level, just as sort of as a middle manager, without any real control and you see these frustrations all the time with franchisees, particularly Black franchisees who are not, they want to use more of their entrepreneurial initiative, but they're given the stores in the worst locations. It's very hard for them to get bank loans. It's very hard for them to get the leases in the most desirable, suburban neighborhoods. So all this stuff sort of, yeah, all, but yeah, I guess I'll say, a lot of these chains were founded before the Civil Rights Act. So, all these guys got actually a great example. And just the last one I'll say is, the Taco Bell was founded by this guy, Glenn Bell, who literally stole all of his recipes and his, from a Mexican store across the street from him, from his failing burger stand. But he had access to capital. He had access to all kinds of resources that other people didn't, and that allowed him to get ahead.
Well, yeah. Well, that makes Run for the Border seem a little more interesting, because he was stealing. You mentioned a lot of franchisor abuses in Chapter 4. Like what struck out in my mind was the ability of a franchisor to use power to terminate, to create additional terms. So you threaten to modify the contract. In a case I teach in contracts, there's this fun case where a garage door dealership, a franchise, was terminated abruptly, leaving them with a bunch of inventory of garage doors. And so the court, says, well, you can have to terminate with a reasonable time period. So they started that quasi contract provision to sort of soften the blow of these harsh terms. So walk us through how termination threats were weaponized. And by the way, why would I assign such a one-sided agreement?
Yeah, well, you have, well, why would you assign such a one-sided agreement if you have parties who have a low enough outside option, that they would agree to it? Why wouldn't you, from a business perspective? But a lot of this is, yeah, I guess I'll put it this way. Yeah, we teach theory of the firm to our students. Whether you're talking about coasts and the difference between markets and firms is that in a firm you're responding to relative price signals, and then I'm sorry, in the market, and in the firm you go from department X to department Y because you're ordered to do so, and then from contract theory about who has the residual control rights to decide what happens with the assets. I think a remarkable thing about franchise contracts that I think it blows everyone's mind when they actually read some of these is that the franchisor actually has the unilateral ability to change any of so there's a contract, and then there's a operations manual that's incorporated by agreement into the contract. And guess what? The franchisee has to follow any unilateral changes the franchisor makes. And that include things like, you got to invest $1 million in remodeling. Do you have $1 million to remodel? I don't. So there's these. It's just the notion of what it means to be an independent business owner, I think has been warped, by this. But yeah, there's all kinds of those. But yeah, I think it makes a mockery of the idea of what it means to be an independent contractor.
Hey, I came across this line just reading the book today. This Rosenberg, I hope I have his name right. He was the CEO of Dunkin', but I think the head of the Franchisor Association, right? He had this line and said, "I'm going to kill every one of you if you join the Franchisee Association." Do you think was he saying that in jest, or was this guy a real gangster?
He is from Dorchester, Massachusetts. I'm
Uh-huh.
from Providence. But who knows how much is bluster. But yeah, this is Bob, the son of William. And this is
I
in the
see.
but yeah, he that is in sworn testimony in Congress. He did say that. Yeah, and I think it's just an example of how the attitude of these franchisors to their franchisees whenever they would try to act like they were employees, try to not even like form a union, but do some kind of, collective action. They responded like an employer would to union busting, which to me sort of gives the lie to this, or shows this whole charade of oh, you're independent contractors, but as soon as you try to unionize, you know what? We're gonna kill all of you. And that is a direct quote. Yeah.
Yeah, I don't know. You don't hear that a lot in the business world, but among
Maybe,
thugs,
yeah, but maybe it just
yes.
doesn't make its way into litigation, or maybe your clients have, or your opponents have better counsel.
Yeah, yeah.
They don't
Well,
sit
let
there
me
You're
and
ask you
get,
supposed
this
to
question.
say,
Oh,
you're
sorry,
supposed
Darren,
to
go ahead.
say, nice franchise. It'd be a shame if something happened to it.
Yeah, yeah. Um, explain, Brian, how the app-based gig economy and franchising are surprisingly intimately related, namely how franchisors in the 60s and 70s fought the tough courtroom and legislative battles that made it possible for Uber, Lyft, and DoorDash to misclassify workers as independent contractors while controlling them as an employer would. I'm curious, like what courtroom battles should we know about? How are they decided? And I guess how is Uber now exploiting this?
yeah, that's I think very important. So I think that yeah, the battles that franchisors and the International Franchise Association fought and won in the 1970s to revolutionize antitrust law are not always understood. I don't think there's been enough dialogue, honestly, between antitrust scholars and labor scholars and labor practitioners and antitrust practitioners, because that is a key element of what has happened. And there's not enough understanding that what happened on the antitrust side was a deregulation of labor markets just as impactful as the deregulation of trucking, of telecommunications, of with the 1978 IRS reform that made it easier to misclassify independent contractors as independent workers, independent contractors. All of this stuff is all part of the same movement, and the franchisor side of it, I think, has not been acknowledged enough. So yeah, what they achieved, particularly with overturning the antitrust precedents of protecting independent businesses from domination control through vertical restraints, through restrictive contract terms, through the price restrictions, through the restrictions on what customers you can serve, what products you can offer, what products you must offer, what hours you can operate. And of course, the most important one, Continental TV versus GT Sylvania in 77. These are cases that overturn that whole idea of protecting the autonomy of small business as an antitrust value. And once you get away from that, you allow companies to dominate and control and dictate and direct the activity of so-called independent contractors while denying them their rights as employees. They do not have the right to join a union. They do not have the right to sue for minimum wage, overtime, and other kinds of violations. And at the sort of extreme end of this, as you're well aware, Hal, you can have McDonald's dictating to its franchisees, oh, you can't even hire each other's workers. Now that would make sense for General Motors. Oh, a supervisor at one plant can't solicit a worker from another plant. That's what it means to be an employee of General Motors. But when you have McDonald's telling these so-called independent franchisees you can't solicit each other's workers, that, as you know, suppresses their wages. and they can get away with it because they are mimicking the internal structures of a General Motors, of an integrated corporation. But guess what? They don't, under the law, they're treated as, oh, these are just separate businesses. These are just, and that's what the antitrust revolution of the 1970s accomplished. And I think, yeah, that hasn't been acknowledged enough from the antitrust side how pernicious that has been.
Nice. We got one last question from the book, and this actually comes from a fan who learned that you were going to come on the show, and she read your book. And she said, can you ask a question? I said, sure, I'll ask this question. And now I'm kind of regretting why I didn't ask it. This comes from Delan. She says, quote, for a reader who finishes your book and feels the weight of these issues, where do you see the most potential for legal or policy-based recoupling of responsibility and control?
Yeah, so that's a great question. There's a number of angles here.
Yeah, how do we fix
so
this
one,
mess?
yeah, right. I think there is a sort of pincer movement you can do. But look, these companies have been able, whether it's Uber, whether it's McDonald's, whether it's Dunkin' Donuts, they've been able to get this sort of not sort of absurd. They can have all the control they want, and they can just push all the liability, all the responsibility onto someone else. That just should not be. There's legislation in a number of different places to try to help deal with this. One way is in New York City, there's legislation currently. It's not quite a franchise, but it's very close to that model to force Amazon to sort of directly hire its delivery drivers so they can't, they're no longer able to outsource all of this to their delivery networks. There's joint employer rules that we've had that twice now under the NLRB, overturned both, unfortunately, by the Trump administration. So that might require a legislative fix under the Fair Labor Standards Act, similar issues. But I think, yeah, basically there can be cooperation between the antitrust side of things and the labor side and the consumer protection side, the vicarious liability side, by just forcing these companies. You got to make a choice. Do you want to have independent contractors, or do you want to have employees? If you want to control your business, if you want to dictate exactly how every employee is going to greet the customer, what hours they're allowed to operate, you can do that. But you got to be liable as an employer for the consequences of that action. And if you would rather have independent contractors, that's also fine. But you got to choose. And I think the fact they've been able to have it both ways is the real injustice of the way that antitrust and labor law have sort of been able to be pulled apart by this business model.
Yep. Well, let me shift gears to our third and final topic, and I want to talk. It's related, of course, but it's a paper that you wrote and published in the Review of Economics and Statistics. It's co-authored with Steinbaum, Gibson, Pinto, and Walsh. And this looks at the effect of no-poach agreements that are imposed by franchisors on their franchisees, whereby if you're a franchisee, you're not allowed to hire or poach a worker from another franchisee in the family or from the corporate-owned stores as well. And of course, that was the debate in this case in which I was involved. Just disclosure, I was the class of workers expert in this matter against McDonald's brought by Leilani DeLandis. And you open the book with DeLandis, and I nearly fell out of my chair. I thought that was a beautiful touch. But she was a department manager making $12 an hour at McDonald's franchise in Apopka, Florida, and she'd go to be the class representative. I've never been in a position before, by the way, Ryan, where I could cite a published paper measuring the impact that I was asked to measure. I almost felt like that was like God shining on me. But anywho, as you probably know, the case settled before it was resolved. It obviously has a long history. It was first denied on summary judgment, went up to the Seventh Circuit. Seventh Circuit sent it back, and then it settled. But I have a question for you in that paper. Just curious, and this is a little kind of a nerd out. Hope I don't kill the listeners with this, but you use this model. Difference in differences model, and you had to come up with a control group in order to tease out what the incremental effect of the no-poach was on the workers. I don't know if you can just kind of put us in the minds, for a layperson, you kind of put us in the minds of how do you go about selecting that control group? What did you ultimately use? And I know you talked about spillover effects that may have caused your results to be conservative. I know that's totally in the weeds. You can leave that one out, or you can hit it if you want. But can you tell us about like how does a scientist, how does an economist think about designing a model in such a way as to tease out the effect of the no poach?
Yeah, so yeah, that was pretty much we just, and by the way, all credit to my much more talented co-authors, Marshall, Sergio, Matthew, and Matt Walsh. Yeah, they did a lot of the yeoman's work on that. I for my dissertation, I happened to have coded a comprehensive data set of 530 franchise agreements. I think pretty much all of them that were publicly available when I was hand coding them in several years ago. And we just happened to get an opportunity. This is how a lot of economic research works, where one state passed there was a consent decree from the Attorney General. The Attorney General, went after these franchisees, franchisors for the no poach agreements, and so we were able to compare. Washington State versus the neighboring states, and we were able to use a staggered diff and diff design for that. Yeah, basically, yeah, for the non-economists, it's just one of those rare, you have a state policy change in one area and you're able to sort of compare with a real control group. And then what we found is that guess what? It does, whether that no poach agreement is, and this is one of the absurdities, by the way, I'll point out about antitrust law, is the way it's currently practiced is whether it has a negative effect on workers can be offset by whether it has, you could say, oh, it has a positive effect on, oh, it helped McDonald's to sell more hamburgers or it helped them to lower their prices. But guess what? It lowers wages. So to the worker, it does not matter whether your franchise and another franchise have colluded against you to suppress your wages. There is this absurd vertical horizontal distinction in antitrust, where I know that we can also argue it's a hub and spoke and all that. But there's this idea that if it's McDonald's telling the franchisees don't do it, that's somehow different. And for the worker, look, your wages are just as low. Your rights have just been violated just as much, and that's the fundamental injustice here.
So let's talk a little bit about the relationship between no poach and non-compete. Both controversial subjects. This one goes beyond the scope of your paper a bit. It seems that some jurisdictions where non-competes are frowned upon would likely increase the prevalence of no poach agreements. Whereas in more friendly non-compete jurisdictions and potentially the FTC, non-competes could be used as kind of a no-poach agreement. Particularly given non-competes are usually enforced by one employer calling another employer, not suing the employee, how it really works. Do you see any sorts of empirical relationships between the two?
Yeah, so in terms of empirical relationships, have I compared the effect of a non-compete to the effect of a no poach? No, I'm not aware of that kind of research being done. But I think that we have enough, economic theory and intuition, and we have research on no poaches to say that the effects are substantially the same or very similar. That they're going to lower your wages, and it's one of those things about the no poach paper. First, there was a controversy about whether we would find an effect at all, and then, oh, obviously, why would we even publish this? Because, it's you're finding that it lowers wages. What else would a no poach agreement do? But there is this theory, that, oh, it encourages, the employee to sort of invest more in their skills, if they have, the commitment that they won't be poached. I find that absurd, and I think that our paper shows, along with other emerging research, that is not what happens. That these are conspiracies against workers to suppress their wages. That's why the workers, by the way, these are actually, I would say, more nefarious than a non-compete, because guess what? You don't even have to be a party to it, to be affected by it. This is the case that Hal is intimately familiar with, that starts the book, is this worker did not know she was subject to this kind of agreement to suppress her wages until she tried to change employers. And she lost a lot. Wasn't able to get a similar job. So yeah, that's what these contracts do. They suppress wages just like a non-compete would, but they're even worse because you don't have to be party to it.
Yeah, so let me ask this question as a policy question. What's that expression, you scratch the surface of any economist and it's just a policy guy underneath, or I don't know, Krugman said something to that effect. But I want to see if I can get you to buy in on this, and I think I can, but let me just try. I don't want to be presumptuous, but you put your finger on the problem in the McDonald's case, and that so long as a defendant can move the case into the vertical bucket, then
Yeah.
it's subjected to the rule of reason standard, which is much, much harder for
Yep.
plaintiffs. You've got market definition, you've got efficiency considerations, right? And our judge, God bless him, he didn't think that McDonald's labor market could exist, and he thought that just it would be a fast food market, and no individual McDonald's or even a collection of McDonald's could have buying power in the labor market as a result. Um, so I'm curious if you would be on board with this idea that I've been peddling to some friends, and there might actually be a push behind this. We can talk more offline if you're interested, of having Congress weigh in and reclassify a bunch of conduct so that it's explicitly treated under the per se standard as opposed to the rule of reason standard. And I mean, we wouldn't just have to stop on vertical no-poach agreements of the kind that we saw in McDonald's, but we could treat a whole new category, different categories of things. The use of a common pricing algorithm, retail price maintenance, a whole bunch of things, which by the way was at one day, as you probably are aware, subjected to the per se treatment, but then was flipped over to rule of reason. What do you think about that as a solution to maybe bolstering workers' outcomes in these cases?
Oh, absolutely. I mean, I think that, yeah, I think it's yeah, the per se, I'm sorry, the rule of reason has become basically a rule of per se legality for defendants. They can hire very expensive economic consultants. They can sort of, the judges just okay, it is not a rule where anyone's rights are currently protected. I'm bright line rules where judges who are not experts in all the minutia of IO and antitrust can just rule on just clear rules as opposed to having to weigh any kind of was McDonald's able to sell more hamburgers? I'm sorry, wages went down by 20% or whatever. That's enough. That is a harm. That's an antitrust harm. Why should we have these offsets? Why should we have these, whoa, it's better to have clear rules. And by the way, that helps all market participants to be able to know this is what I can do, this is what I can't do. But right now, it's a license to sow doubt in the same way the tobacco industry did, for decades. And I think it's nefarious.
All right. Well, I'm going to count you as a supporter of this bill. Might have you testify in front of Congress too. Well, look, thank you so much, Brian, for coming onto the show. And I just want to commend everyone again to go out and race out and go buy a copy of Chain of Command. It was a great book. And read about it, tweet about it, and tell your friends to go buy it too. Brian, thanks so much for coming on the show.
All right. Thank you, Darren and Hal. Thanks for having me.